We're going to move on now and continue the discussion with our legal experts to help us sort all of this out. Former federal prosecutor Doug Burns and distinguished professor at Touro University, Thane Rosenbaum. All right, Doug, I want to start with you here. Of course, we know the Trump team vows to appeal this, to go after this. But more broadly, does this help or hurt President Trump?
I think it helps him. It's interesting. Thane and I were discussing earlier, and he made a very good point, which was that Trump has been arguing, look, this isn't about them going after me. It's about you folks. But now, for the first time, they really are going after people. In a democracy, right, you hardly need me to say voters should determine who is going to be elected, not four elite Ivy Leaguers, by the way, all four of them. It was a 4-3 split. That's important, by the way. It's a razor-thin decision. And I think SCOTUS, the Supreme Court, will reverse it. I can't give you a number, but it might be 6-3 instead of 5-4. And by the way, there's a lot of legal avenues that they can use without getting into the big issue about was it insurrection? Did he cause it? No. Does the local statute, can you really bring this claim under the Colorado election statute? Is the president really covered? There's some legislative history indicating that he may not. And there's a whole host of legal issues which provides them a very good legal off-ramp to reverse this, in my view.
Yeah, I think it's important to note we have a panel of judges, again, like Doug, you said here, 4-3. They believe that they know who you should be voting for or not in Colorado.
Exactly.
They're not giving you that choice.
That's where we've entered into. It's a scary time, Thane. How quickly does this, or do you think it gets to the Supreme Court?
It definitely goes to the Supreme Court because it raises a number of constitutional issues, including whether this Section 3 even applies to the president. Right. The lower court in Colorado said that it didn't. And remember, this is now the four states already have said that on procedural grounds this doesn't apply.
Right.
It's very interesting. This case is very similar to the other criminal cases and civil cases because it's a stretch. You're going to 1863 exactly. to take the 14th Amendment, a subsection that's never really been used, certainly not against the president, by a Colorado court that's nowhere near Washington, D.C. So they made factual findings. They said there was an insurrection and the president caused it from the Rocky Mountains. They decided in the Rocky Mountains without a jury, they made those findings. No other court has concluded either of those important factual findings.
Right, that's why we're calling it the Rocky Mountain Low today.
Yes, that's right.
But also, speaking of that 14th Amendment, Doug, first of all, we have to go back to, is that what the framers of our Constitution intended? I mean, going back again to Constitution, but also you mentioned something very important. In the 14th Amendment, there is a very specific phrase that has been very clearly left out of the references to the 14th Amendment here.
No
Tell us about that.
Well, first of all, there's some legislative history, apparently, discussions at the time of the ratification where they were going to put in president specifically as an officer, and then they didn't put in the president. And so we lawyers always take that to mean they discussed putting it in, but then they didn't. But then you look at the historical 7th grade social studies, very important. This was put in Reconstruction after the Civil War to make sure that Jefferson Davis, for example, the president of the Confederacy, couldn't become president of the United States of America. And the most notable thing I saw today on the screen, rarely used. So right back to Thane's point, every one of these cases, hardly ever used, novel interpretation. This is what you hear over and over again. So to your question, which I wasn't avoiding. Now, this was an 1868 Reconstruction move, and of course now they apply it 160 years later.
Let's take it a step further and talk about the other indictments against former President Trump here. They're all a stretch. Thing, you just kind of coined it, and I'm going to start using this. I'm going to steal it from you.
At least you tell us.
They're stretching the law so badly in these cases, and now they're doing it in the court system.
RICO, a crime family out of the Atlanta case. The Espionage Act in Florida, the Espionage Act is for enemies of the state who take documents and share it with foreign governments or sell it. He kept it in his sock drawer. Maybe it was irresponsible. Does that make him a spy? Does that make him the enemy of the state? All of the campaign finance law violation by paying off the porn star? What? So in each of the cases, they took a piece of the law and said, let's just try to bootstrap this in, because we don't have anything else to say. And in this one, I think, is, as Doug said, the one that's most dangerous. Because this is the court saying, remember, the Founding Fathers believed in representative democracy. They wanted people to elect their leaders.
Yep.
They didn't want unelected people taking away their votes, and that's what's happened in Colorado.
And I do want to mention there are other states that have similar litigation pending
no,
here.
there's a bunch of them.
Is this
Maine,
gonna set-
including Maine. Right.
That's right. Are we seeing precedent set here? We're going to discuss that later
we'll
in the
see.
show
That's
here.
right.
But Thane, Doug, gentlemen, as always, thanks for coming on. We appreciate it.
My pleasure.
Anytime.
And coming up, we are going to focus on Israel, where renewed talks for a ceasefire between Hamas and Israel are on the table. More on that news after a very short break. Stay with us.